The Supreme Court recently handed down huge rulings on parental rights and religious freedoms. But what do they actually mean for Virginia? We're going to get into that today as we explore how the court's decision upholding a state ban on these invasive gender transition procedures for kids strengthens efforts to protect children nationwide, as well as a decision siding with parents in Maryland that reinforces what we've been saying all along: parental rights don't end in the school parking lot. From the Family Foundation, I'm your host, Candi Cushman, with our senior legal counsel, Josh Hetzler. Welcome, everyone. Glad to have you with us for another episode of Speak Up Virginia. You'll notice I have a guest with me, my colleague Josh Hetzler, senior legal counsel for Founding Freedoms Law Center. Welcome, Josh.
Thank you for having me.
I'm so glad you're here because we have so much to go over with the Supreme Court decisions that have been happening. But first, give us some updates on some of these legal cases. You guys have been really shaking it up across the state lately.
Yeah. And one of the biggest ones is what we call around here the Loudoun Three. And the listeners will be familiar with this case. It's the three sophomore high school boys in Loudoun County who are under formal investigation for sexual harassment under Title IX. And why so? Because they simply asked why there's a girl in their locker room because of Loudoun's policy of allowing, boys and girls spaces and vice versa. You may recall that one of the students, our Muslim student, had the case dismissed against him. But for our Christian clients, they double down against them and are very much discriminating against them, we believe, based on their religion. So that case is ongoing, and today's actually the deadline for our final response, and then they'll have a few weeks to make a decision. And so we're eagerly waiting on that. And in the meantime, the Department of Education, the Trump administration, has expressed interest in this case, and we're trying to work with them to bring pressure on Loudoun to do the right thing.
Yeah, thank you, Josh. Now, what about this other case with the real estate?
So that's another case of national implication with Wilson Fallber. He's our realtor client, and he was brought up on ethics violations charges for hate speech for posting Bible verses and making biblical statements on his personal Facebook page about LGBTQ topics. And we believe that was wrong. It violates their rules, but it's just fundamentally wrong because realtor essentially holds a monopoly over the whole industry, and he's being punished. And they punished him once, and then the same people who made the complaint made another complaint, and we just represented him on another ethics complaint. They found him guilty on the first one. We're waiting on the second one, but we may be in a lawsuit very soon because of what the National Association of Realtors, has done to Wilson.
And it sounds like a painful process. Sounds like he has to go through these several hours long hearings or something.
Yeah, often the process is the penalty, right? And in addition to the fact that they told him he has to go to these, what we're calling re-education training to sort of re-indoctrinate him and tell him why his ideas are wrong. But I will mention that a few weeks ago, because of, in part, our efforts, the National Association of Realtors met in Washington, D.C., and they actually changed their policy on this. They actually were responsive to what was happening. I think they're concerned about lawsuits. So that's been a really good development that we've been able to help bring about.
And thank you for continuing to defend these core religious freedoms because, we don't all have to agree on everything, but our founding principles cherished the right to have the freedom to have religious beliefs that we can express in public without having threats to our license.
And no more so than in the Commonwealth of Virginia.
Yeah. All right. I am really eager to just launch into these Supreme Court cases. That's what I really want to talk to you about today, Josh, because, every year, especially during the summer, the Supreme Court hands down these cases, usually in June, and people are watching to see what's going to happen. They're glued to this. And I just feel like this summer was especially monumental because they handed down some huge cases with wide-reaching ramifications, especially on parental rights and religious freedom. And there's a couple of these cases I really wanted you to weigh in on, especially as it impacts Virginia. And the first one I wanted to start with was this case involving states, whether states have the right to ban these invasive, oftentimes harmful, so-called gender reassignment procedures, or gender transition procedures, you'll hear them called, but they involve, hormone blocking or, removing bodily organs. It's pretty drastic, irreversible. And Tennessee,
we're talking about for minors, right?
Yeah, for children. This case
who
involved
really
children.
Can't even consent, who have no idea really what they're even doing, and they can't understand the long-term ramifications, right?
Yes. All right, now, before I start asking you, I just want to mention that if anybody knows Josh in our office, they know his catchphrase a lot of times is biology matters. You have said that many times, and it appears
it's working
the Supreme
because
Court agrees.
You're using it.
Yeah. Well, the Supreme Court basically said that with this case. Let me just set up a little bit, and then I have a question for you. So this started out of a lawsuit brought by the ACLU against the state of Tennessee because the Tennessee had signed one of these laws prohibiting invasive gender transition procedures done on children. And the justices ruled 6-3, and Justice Roberts was writing the majority opinion. It's a major win for parental rights and people advocating for protecting kids. So, Josh, help us understand the significance of this case, first of all.
Well, I want to mention that at this point, around 20 states have passed laws to do this very thing. And hopefully Virginia will be the 21st soon.
Wouldn't that be wonderful?
We've been trying for the last few years, but haven't been successful yet. But, I want to step back for a second and say it's amazing that we're even here. It shows you a lot about the culture that we even have to have a case that goes to the Supreme Court of the United States just to answer the question of, can a state pass a law protecting children from mutilation, basically, something that sterilizes them, something that they can't really consent to. And not only that, something that defies nature. We know that a male cannot become a female and a female cannot become a male. These are the basic facts of life. We shouldn't have to have a Supreme Court say that, yes, that's true, and you can have a law protecting children. But that's what happened. Now, thankfully, that's what the Supreme Court said. It should have been 9-0, but it was 6-3. But in essence, the court ended up deciding that the state only had to satisfy what's called rational basis review, so the lowest level of review. If the state has any basically rational basis for doing it, they're allowed. And it's because the Chief Justice in this case said they weren't discriminating based on sex or gender identity. They were discriminating based on the type of medical procedure and the age of the patient. And so they still allowed it for things that were unrelated to gender transition, so-called.
Like a premature onset of puberty or, some bodily defects that they're trying to help alleviate.
As you said, if you're doing it for the purpose of basically mutilating a child and to help them pretend that they're a sex that they're not and they can never be, then that is within the right of the state to do that. That is a rational, and that is constitutional.
Okay, let's break this down a little bit. But first, let me just share this compelling moment where Justice Kavanaugh actually recognized that there is a general movement backing away from these experimental procedures because, now we have people coming and saying they're detransitioning, saying this was harmful for me. I did not have the ability to consent to this as a child, and now I regret that I can't have kids. I can't restore what I lost here when I didn't understand. And he talked about how because of this and the experimental nature of it that they're seeing, they don't actually understand all the ramifications, that we shouldn't be experimenting on our kids like this, that a lot of states, like Josh said, at least 20, are backing away from this, but also Sweden and England, major medical organizations retracting, going the reverse. And still you have people, the ACLU, pushing the opposite direction. So let's just listen to Justice Kavanaugh commenting on that.
If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports? If it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as pretty heavy yellow light, if not red light, for this court to come in, the 9 of us, and to constitutionalize the whole area when the rest of the world, or at least the countries that have been at the forefront of this, are pumping the brakes on this kind of treatment because of concerns about the risks.
Well, Josh, I want to get more into some of the biology of this and what you were talking about, where they are, it's based on the medical purpose and not sex, because the other side was trying to claim discrimination, against sex. But first, Justice Kavanaugh did mention female sports. So I wanted you to weigh in on, is this giving us a foundation for doing more to protect female sports, both nationwide and here in Virginia?
Well, it certainly helps. It doesn't directly address the issue of sports. In fact, the Supreme Court recently just decided to take a case dealing with that very issue next term, and I think we'll talk about that in a little bit. But so it doesn't directly address sports, but you can see that it has the same general theme, a recognition of the problems and the legal absurdities of gender identity. Mm-hmm. And that's really what it does. I think you can see a trend with this Supreme Court taking cases like this to correct what's being done. And so I think we can be very hopeful about the movement back towards biological reality, back towards sanity, including in sports because of this, because there's a recognition that biology matters.
All right, let's get into that biology part a little bit. So the court specifically pointed out that according to the FDA, quote, biological differences between men and women are going to contribute to how the drugs impact bodies and just differences in the safety of all that. So again, biology matters. And then there's the famous Justice Ruth Bader Ginsburg quote, where she said the physical differences between men and women not only exist, but they are inherent and enduring. And to Kavanaugh's point, or you were alluding to earlier, Josh, you were talking about how they're looking at whether there's a rational basis for the law, and I think that's very interesting. And the court was just amazing explaining that the legislator had rationally determined that, puberty blockers, hormones to kids can lead to, quote, becoming irreversibly sterile, having increased risk of disease and illness, or suffering from adverse and sometimes fatal psychological consequences. So, they're looking at that as that is enough of a reasonable...
That's more than rational.
Yeah.
That seems like a compelling reason, but they've certainly met the lowest threshold, which they have to meet.
All right. They also pointed, as I mentioned, to the experimental nature, that the children lack the maturity to really evaluate the risk and consequences of this. But I also wanted to talk a little bit more about, you mentioned that this whole thing is interesting about the left was trying to say that they're discriminating against sex, and the Tennessee attorney's argument was, no, we're making these decisions based on the age of people.
Yeah.
Because adults, I guess, in the state can still do this.
Yeah.
And the medical purpose.
Yeah, so the majority opinion ultimately rested on the fact that it was about age, it was about medical purpose. Now, I think some of the people, some in the majority wrote concurring opinions, basically saying, look, we would have addressed the issue of whether gender identity is a protected class or not. And they basically said, no, we don't believe that gender identity deserves any kind of heightened scrutiny like race would, for example. And so I think some of the concurring opinions gave us some good things to work with, but it wasn't in the majority. But I think you see the court taking this incremental step, but it's still a very significant incremental step.
In other words, gender identity is not immutable. It's not unchanging, as we see from the detransitioners. Right. So it's not the same as special protections for immutable characteristics.
That's
right. That's interesting. So they stopped short of that, but they upheld a state's effort to ban these kind of invasive procedures based on the fact that they have different consequences for children and the way they're being used medically. Yeah. All right, so back to Virginia, is this going to help us in the future get through more like the help not harm laws that you guys have been working on?
I think it certainly gives momentum because oftentimes when we bring these bills to do this, you'll get pushback that says, oh, it violates the Equal Protection Clause, for example. And we'll be able to say, no, the Supreme Court says this is perfectly fine. So it gives us more momentum. Of course, we have to have the numbers in the legislature to actually get it through. But this removes one of the major hurdles.
All right, the other big case I wanted to talk to you about is this one coming out of Maryland. Let me look here. I think it's Mahmoud, if I said that right.
I think that's how you say it, Mahmoud.
Mahmoud versus Taylor, coming out of our neighbors, Montgomery County, Maryland. And this is also going to have a really big impact on this whole battle that parents have been fighting nationwide to protect their children when it comes to sexually explicit and graphic indoctrination in the classroom, in the curriculum. So help us understand this case, why it's so important.
And this issue is so huge. It's one of the biggest issues that we've been dealing with for probably the last 5 years, from a policy level, but also from a legal standpoint, helping parents get their kids out of this sort of curriculum. In this case, it was about the school initially allowed opt-outs for religious reasons for LGBT books that were being read to preschoolers and elementary. And then apparently what happened, so many parents wanted to opt their kids out of it that they just basically rescinded the policy and says no opt-outs for religious reasons.
Yeah, and that's leaving like 70,000 parents, I believe, in that district without opt-out options.
Yeah, it should be a good indication that if so many people want to opt out of it, maybe it's not a good thing to do.
Yeah.
But we've seen this before where they're afraid that too many people are going to opt out, so they say no opt-outs. And here, the court ended up saying, no, you can't do that. You've got to inform the parents about the fact that they're being read, and then you've got to give them an opportunity to opt out, at least on religious bases. Now, unfortunately, this case doesn't necessarily protect those parents who have non-religious objections. But for those who have religious objections, they're absolutely protected here.
Well, this case was noteworthy for many reasons, one of which this case, the original effort to defend, to bring a lawsuit and defend their rights to opt out was brought by several parents of many different religious backgrounds. So you had Muslim, you had Christian, Orthodox, Jewish, Catholic. And so that's noteworthy that many joined together to stand up for this right to opt their kids out when something's conflicting with the values they're teaching at home. And then just the whole thing also, Josh, of them reversing their policy and deciding, we're not going to let the parents opt out after all. But they were making arguments like, we can't have parents just subjectively deciding they don't want this and that, because they were infiltrating these topics into classes that were not sex ed. It's reading, English, that type of thing.
Yeah, that's part of the challenge with this topic in particular. Historically, usually in every state, there's an opt-out for family life education, so for sex education. The problem is that they're injecting this into basically every subject possible, and it's no longer just family life education. But there's no statutory right to opt out. So the question is, notwithstanding whatever the statute allows, like in Virginia, we have a statute that allows it. But what does the Constitution permit? And so let me read you the test that the Supreme Court laid out. It says that the question in cases of this kind is whether the educational requirement or curriculum at issue would, quote, substantially interfere with the religious development of the child, or pose a very real threat of undermining the religious beliefs and practices of the parent wishes to instill in the child. Now, that's a really broad test, and who knows all the things that it might apply to in the future. For example, if you object to evolution in science, this may give you the opportunity to opt your child out of that part. We'll have to see, but I
think you just scared all the leftists.
Well,
go ahead.
Well, if it meets this test and it substantially interferes with the religious development of your child, or it's a very real threat of undermining the religious beliefs, then you should have a right to opt out. If so, that's the test, and I think it's a great test.
Well, this is especially a flashpoint with this radical transgender indoctrination being forced on kids in so many schools, including here in Virginia. And I just want to list some of the books it's crazy. You're talking about why is this even getting to the Supreme Court, and you have 9 justices looking at talking about elementary school books. So Let me just read some of the titles of these books. We're going to flash some of the book images on the screen, and you can see why all these parents objected, but there was Pride Puppy. Again, you're talking about really little kids. Pride Puppy. I think that might be the one where they asked them to go and look for terms like leather, and it was just very disturbing. But anyway, Prince and Knight, Uncle Bobby's Wedding, Born Ready, The True Story of a Boy Named Penelope, and it goes on and on. Let's just let you hear from some of the parents that were involved in this case. This is a quick video from the organization that was defending them, helping the parents, Beckett Fund. Let's just hear from these parents.
The core responsibility for the education and also the values being instituted into your children. Is it the parents? Is it the state?
Now I don't know what my child is being taught. I don't know what my child is being fed mentally and spiritually, and that's dangerous.
We were made to feel like we were somehow pariahs for saying, wait a minute, Montgomery County, let's bump the brakes.
For a child of 5, 6, 7 years old, introducing any type of material that has to do with sexuality, I would be absolutely against that.
Parents needed to come together and speak up to get our voices heard.
There's a lot of parents from all different religious backgrounds, from all different socioeconomic classes, who are saying this move by Montgomery County is stripping parents of their basic rights.
All right, Josh, we know, because you and I have talked to them, there are lots of parents like this in Virginia. So how is this case going to impact them?
Well, it's interesting you say that. There's actually a resource we have on our website under parents at foundingfreedomslaw.org that gives parents sort of a sample opt-out for this very type of thing. So we had this prior to this case, but now we need to update that with some of the language from this case. But what it means is that parents now have a much greater opportunity to opt their children out of things that they object to for a religious basis. And that could be any number of things. Parents have different religious beliefs, but they need to be, to a certain degree, for controversial matters, they need to be made aware of it. And then once they find out, they've got to have the opportunity to opt out. Now, they may not know how to do that or how to word it. They can certainly reach out to our law center, and we can help them do that. But so it just opens up a world of possibilities to protect your children from the types of indoctrination that are really repugnant to your religious beliefs.
And, I should mention, this Supreme Court case, it's actually still going on. The case itself is still going on because the Supreme Court said there was reason to put a hold on them not letting parents opt out, but it still has to go back to the lower courts. But regardless, the court established some key principles. It's the bigger principles, not necessarily the case details that matter here, and that is them finding that this kind of policy doesn't infringe on the religious freedoms and parental rights. And now here in Virginia, we did recently get a law passed that does say parents need to be notified if there's sexually explicit material being used in the classroom, and they can opt out of that. But even so, we still had these last few days these efforts to villainize school boards like in Hanover that have responded to parents taking explicit books off the library shelves.
Yeah, so the issue, the law addresses curriculum, and there's this question about whether books in the library count as curriculum. And so some school districts, in the process of removing sexually explicit books, which is their prerogative to do, they were pointing to this statute and saying, see, these are sexually explicit. And they got their hand slapped for doing that, which I think is ridiculous, because the fact of the matter is school boards have inherent authority to choose which books are going to be in their libraries. They can't have a billion books in there. They have a limited number, so they get to choose. And they can remove ones that they think are not appropriate. But in terms of letting parents know, we do have this law that says, anything that is in the curriculum that might be sexually explicit, you have to let the parents know in advance and give them the opportunity to opt out.
Yeah. I think the main point is parents deserve a voice, and Hanover was listening to the parents, and the school boards deserve that kind of respect. So,
Right.
All right, well, you mentioned earlier that there's another case that the Supreme Court has agreed to hear. Tell us about that real quick.
Yeah, so this one is called BPJ versus West Virginia, and I think there's a companion case from out of Idaho. We actually signed on an amicus brief for this case, but this has to do with whether states can have laws that protect girls in sports, right? So this is a huge issue, and Virginia has been impacted because of this. Was a Fourth Circuit decision, so Virginia is bound by a bad decision
The Grimm's
from
case.
Grimm and BPJ. So I'm very excited about this case because I think the Supreme Court is going to set straight the issues that have been happening in Virginia that have given school boards enough of an excuse to not do the right thing. Even though I don't think they can use those cases in the way they're trying to, but places like Loudoun are saying, no, we gotta go with the Fourth Circuit. And now it looks like the Supreme Court is about to correct that.
And then there's one other case also, I think it's coming out of Colorado, interesting, involving the free speech of Christian counselors that
I think it's
you guys
called
just worked on.
Yeah, I think it's called the Childs case, if I'm pronouncing that correctly. But that has to do with so-called conversion therapy and the ability of counselors to have conversations with minors who have unwanted same-sex attractions or gender confusion, and just to basically help them realign their mind with their body and how God has created them. So some states have said that's illegal. You can't have those conversations. Thankfully, in Virginia, we just won our lawsuit that said that that's unconstitutional. But that only applied to Virginia. And this case should apply nationwide. And I hope I believe they're going to say that this counseling censorship is not permitted.
All right. That is encouraging. Thank you for that very important update. So I guess we can all be praying because I think the Supreme Court term will begin again in October, and we'll be getting news about these hearings. So let's all be in prayer about that. But in the meantime, if you want to help efforts now, check out Founding Freedoms Law Center website. We're going to put it on the screen here, foundingfreedomslaw.org. Make sure you go and get the latest updates on their cases, learn how to support them, because you're working on right now, even before these Supreme Court cases come up, you guys are working right now here in the Commonwealth on these exact same issues, whether it's the Loudoun 3, the Christian realtor, or the so-called conversion therapy, the free speech issues involved with that. So thank you for all that you're doing. And I encourage everyone to pray and support and pray for Josh and his colleagues. So any parting thoughts as we head out here?
I think we should all be encouraged because very good things are happening at the Supreme Court.
Yeah.
And we've got, and with President Trump, he could appoint more conservative justices if any of them leave. So this is a really good opportunity for us, both in Virginia and at the federal level, and we should be very grateful.
Yes, well said. Well, thank you for joining us today. Remember, you can share our Speak Up Virginia playlist on YouTube if you want other people to hear this important perspective that Josh provided today. We need to be getting the word out. Remember, we are stronger when we speak together, and we'll see you next time.